Thank you so much, Malcolm, for setting the context well. Before I, look towards my panelists, in brief, the reason and the rationale why we, thought of setting up this session. As you know, we, as Data Security Council of India, are looking at, privacy protection, data privacy protection, and more importantly, the implementation aspects, different facets, of course. Because we realize that organizations across the board may not be at same level when it comes to undertaking their privacy journey. Some are still in the exploratory phases. They're just trying to make sense of different elements that come together when it comes to overall privacy governance. Some organizations have already taken that plunge and are in the process of deploying various different kind of solutions. They're in the process of optimizing their processes and, of course, building their capacities within. So again, this session at the end of the day is intended towards all such organizations. We have a preeminent lineup of experts sitting right next to me, and we'll just try to understand what privacy operation means in the first place. So Akanksha, I'll start with you. I'll go in that order, and Anuj, that was your suggestion as well. So in terms of deconstructing privacy operations, and of course, given the audience primarily hails from the financial sector, and you yourself representing one of the securities companies and having taken over DPO role recently. So if you were to, in simple words, deconstruct what you mean by privacy operations in an enterprise context, what would be your take on that?
Okay. So first thing first, I would like to say that initially when we thought about the privacy, it was more related to, a compliance checkbox, a tick mark wherein privacy was never part of the culture as a business, or you can say it was never into the risk register. It was more as a looked upon as a cost center to the organization. Let me put it this way, wherein if we talk about today, there's a whole change we can see in the last almost like 4-5 years, wherein organizations started looking privacy as a concept, more into your operational discipline, wherein they can see there's a lot of things they can do towards that. They started looking into putting privacy as a culture, privacy as a code, privacy for their own scaling of the business operations, and a lot of business resilience, data resilience, and I can say the cost optimization working upon, so that we can have privacy as a base, privacy as a design in the organization culture. At the same time, they'll be able to scale the business the way they want to expand.
Right. So thanks for the initial remarks. Priyanka, I will come to you. You're representing Aditya Barua here. So if you were to, in very simple terms, talk about, what comes to your mind when we say privacy operations. We talk about, conventionally privacy governance, how it differs from privacy governance. So what would be your take?
So let me take a step back. What was traditional privacy for any organization? Like Akanksha here mentioned, only in the recent years that financial services companies have started taking privacy seriously. And I would beg to differ on one aspect, that it is not because of good governance, it is because of the, what I would say, regulatory scrutiny that has come in. The way RBI is now looking at all of these
Absolutely.
requirements very stringently. But if you compare what RBI requirements are with what the DPDP Act is saying, it's very different. Yeah. While privacy is still in a way a checkbox exercise, if you look at something as simple as consent, how many customers have actually come back to you and said, I want to withdraw my consent? Because that is not available under RBI guidelines. And that is what is going to change with the DPDP Act coming in. So if we look at traditional privacy operations, they were very manual in nature. Excel sheets and things like that, physical papers, forms being signed. With newer laws and more strict mechanisms coming in to enforce these laws, I think technology is the only way forward. It will help you to scale your operations in that way. If you look at any financial services company, they have so much of private, personal data that it is not possible to manage all of this manually. It is, so privacy right now, I would say, is a paper tiger. We need a real tiger. So that's why we need tech to enable that.
Anuj, why privacy operations suddenly is important for us? I tried, we as DSC are looking at it more from an aggregate level body. but somebody who is into providing solutions to different kind of problems, which crop up at enterprise level in privacy. So why privacy operations are of suddenly so much interest to us?
So see, I'm going to give you a very different perspective because we interact with a lot of clients, be it financial services, non-financial services. First and foremost, as they say, charity begins at home. Look at us. How much are we bothered about our privacy, right? Today, our PAN cards, Aadhaar cards, all our data is all over the place, and we are not even bothered, right? It's being used, misused. I don't know where it is, right? So that's one thing that I think this privacy operation or the new act or the law, or like for that matter, if you see the PAN card act or the Aadhaar card act, PAN card act was out in 2018, Aadhaar 2019, where it mandates all FSI or everyone, if you are collecting PAN card or Aadhaar card data, you have to mask it. Has any organization done that? Probably not. Yeah, I'm just sorry, I didn't mean that, but I'm just saying, how many of them have taken it seriously? And it's a penal code, it's a criminal offense, right? So privacy operations, again, till date has been a tick mark. Somewhere it's been a compliance. If I talk to my customers, they say it's a headache. Right now we've got another data privacy operator. Now we need to now manage her or him as well. Right? I'm sorry, two women on the table. That's why I said that. But coming back, I think DPDP is going to change the game. And the only way this game is going to change is as we deploy technology. It's just not possible to do on Excel sheets. It's just not possible to do manually. You need to know where your data is lying. You need to know what you need to do with it, whether redact it, encrypt it, decrypt it, do what you want. But you really need to know. And then you need to have the artifacts and the proofs that you've done that. Right? So it's going to be a very interesting era. I think this is the only act which will cut across all businesses. RBI governance, IRDA, SEBI, they only cut across certain elements of business. This is going to go to one and many. So it's going to be a very interesting time in the next 2 to 3 years. And I think as citizens of India, we should adopt that. We should push for privacy or our own privacy because it's eventually going to impact us as individuals.
No, thanks. I think that's an interesting perspective. Akanksha, I would like to come to you because even when we were conceptualizing this topic, so making sure that all the data transactions, and especially you come from an organization where the number of transactions happening are literally mind-boggling. So how do we make sure that, how do we set up our processes in such a way that whatever transactions are being done, they are legitimate, especially from a data privacy standpoint, or at least being looked at. I would refer to the conversation we were having just outside the room, that bringing all the stakeholders within the organization on board from, you were talking about ROPA, right? So how do we make sure that that legitimacy automatically gets embedded into all the transactions that we do?
So the kind of scale we operate, the number of transactions we handle, so looking at that manually, honestly, practically, it's really, really impossible to have all that legitimacy at in place. However, if we have my automated systems in place wherein from, data entry, the moment the data enters into my ecosystem, if my technology is at right place wherein we have the right architecture, example, if I build my privacy as a code, if I have my policies as a code, if I have my policies built in my CI/CD pipeline, wherein we know that automatically the moment data is going to get entered, we have automated data tagging, data classification is happening at the same point. I'll just take with an example. Let's say a customer is getting onboarded. So we have all the, customer's personal data in place. The moment customers upload this information or give me this information we get from the aggregator, whatever way, or directly from the customer, if this data is automatically getting classified, getting tagged, and at the same time we have all those consents and everything in place. So related to that, based on the access-based roles, we know that how many people are going to, will be able to access it at the same time. If my marketing, if my analytics team, anybody is going to use it, that is again depending upon the consent, whatever they have given. If the consent allows, it should be, otherwise it should not be. So if all these things are automated, then I believe we'll be able to scale it in such a way that we know where is my data, where it is lying, what purpose it is going to get used. So my all business processes has to be built, back to those PII elements. My ROPA has to be in place. Then only we will be able to track and, get back to those PII elements in the journey.
Right. I think just a follow-up question for you, Akanksha. You talked about, interestingly, product architecture,
Yep.
right? So this overall scheme of things when we were talking about privacy operations. So what relevance does a product architecture holds when we are talking about privacy by design or when we're talking about operationalizing? Because privacy by design is a concept. It has certain set of principles. So from a product architecture standpoint, so how do you think that operationalization of privacy by design could happen?
I'll just take, again with an example because to able to connect. For example, if I take any developer, for example, who's going to work upon, say, onboarding journey. Once again, I'll take that example because therein we have a lot of PI data in place. Imagine because the developer doesn't understand the privacy concept or maybe not bothered because that, in knowledge gap is still huge. People do not take privacy as seriously. I mean, how many of the coders we think that they are more worried about the privacy than their own, code schema. So if we, and they put something in the, let's say in the comment or maybe in the logs, my PI data is going, unencrypted, non-tokenized. So that all practices needs to be built in the place at the ground. Until unless these practices are not in place, end of the day, some or other day, this is going to buzz off.
Got it. Priyanka, you did mention about DPDP, and of course, goes without saying that we can't really escape the ghost of DPDP. And given that we are waiting with the bated breath for the rules, etc., so let me come to you from two standpoints. One is that we really talk about, we so often talk about compliance burden, that DPDP has put so many obligations and expectations on organizations from a privacy standpoint, especially the significant data fiduciaries, right? So, how do you make sense of these multiple expectations and obligations? Because DPDP is one. Because if you have international, so many other jurisdictions get involved. So how do you optimize this burden, so to speak, especially from a privacy operations standpoint? Because then contracts get into picture. You have to continuously build that regulatory intelligence and all those aspects. So your take would be helpful here.
So there were already RBI, IRDI guidelines in place. In addition to that, now we have the DPDP Act. Wherever you have multi-jurisdictional presence, you have other privacy laws that are in place. So there are a lot of requirements, under all of these laws. But if you see, the underlying requirement is based on the principle of privacy. So if you are clear about the principles, most of your compliances get taken care of. These principles can be your minimization, consent, all of that. But having said that, there are definitely incremental requirements. So firstly, you need to have a common harmonized framework within your organization. That is very important. Instead of blindly following one law after the other, if you have a framework in your organization which takes into account these laws, and there are many tools also that help you build that framework, where you can map out the requirements under various laws that are applicable to you. And if you look at it separately, it could be a huge compliance burden for you. But if you harmonize it into one framework, it becomes easier for you as well. Secondly, you need to know what data you have. I think my other panelists have also touched upon that. You need to know where your data resides, what is your, in layman terms, a personal data inventory. Once you have these two pieces in place, you will know what controls to put in what place. Because you can't, you can't protect what you cannot see. So you need to understand what are the requirements, and you need to understand what is your canvas that you want to cover. If you look at the different regulations, most of the regulations have some common requirements. Consent by far is a golden standard for all privacy laws. So that is something we cannot do away with, and that is something all organizations need to start getting into. If you look at the difference between DPDPA versus the existing banking laws or financial services laws that are there, DPDP gives more right to the individual. It's more meaningful rights. It's not just that you give a consent and you process your application. It is a more meaningful right where the person can question you, they can come back to you. And that is why I believe that this is going to be the game changer that is going to require all of these other regulators to come together and enforce it in a more stringent manner. At least for non-regulated companies, there is still some time to go. But for those that are already regulated by other sectoral regulators, these sectoral regulators are also bucking up now. They are also, getting ready to enforce the compliance with DPDP Act. So it's not very far away, and I think there's, organizations have to start in their journey towards compliance.
And just to follow up, with respect to rules, a lot of organizations are still waiting, right? Draft rules came in, feedback was sought, extensive consultations were held. We were also a lot of us were part of that. Do you think, what would be your advice to the organizations that bases the draft rules? Should they be kickstarting the journey, or should they be still, be a kind of a fence sitter waiting and watching?
So I think I'd like to ask one question to the audience. How many of you already have a personal data inventory in some form or the other, like a ROPA in some form or the other? A show of hands. See, we don't even have 50% of the audience that has a ROPA. The rules will not come back.
That's hardly 5%.
Yeah. So the rules are not going to clarify on that. There is nothing new coming in the rules about having an inventory. So you need to understand what data you have. You have to do data discovery, if need be, depending on what type of data you have, whether it's structured, unstructured. So all of that is something that needs to be done right away. Even if the rules come in, say, 2 months later, they give you another 8 months, 10 months, 1 year. Do you really think, given the canvas that you are trying to cover, given the different lines of businesses that you have, do you think within 1 year you will have an inventory ready, a consent management platform ready, implemented and ready to use, the training awareness going to the last mile? So all of this is a 2-3 year journey, to be honest. And if you are a regulated entity, you may not have the luxury of 2-3 years. So your compliance will be measured on the day that it becomes effective. So you don't have that time. So this is the time that you have. Even in our discussions with MIT, this has come up. I think DSCI was also there in those discussions, that the officials are saying, don't wait for the rules. When they said that they will be giving 2 years, like GDPR gave 2 years for compliance, the MIT might even consider the last 1 year that they have given into those 2 years. So you were told that there is a law that has been notified, it has the president's assent, so it's not changing. Only some clarificatory guidelines, rules will come in. But if you knew the law, why didn't you start your compliance from that day, is the question your regulator is going to come and ask you. That is why I think it is with a sense of urgency that we need to take steps and not just wait for the law to come in. Also, another thing that we hear a lot, since I work at the group level at Aditya Birla Group, and a lot of our group companies also have similar issues, because I understand there's a lot of buy-in that is required from senior stakeholders, budgetary buy-ins basically. And everybody is saying we'll do it after 2 months, 3 months. There are many organizations that say that. But imagine if everybody comes at that time, do you think you have the resources to handle so much at that time? So it's best, considering that financial services is a high risk game. It's like if any of you have seen, what is the India's Got Talent, it's like those flaming swords that you are juggling, and one wrong move, you're not just out of compliance, you're out of business. So for financial services, I think it's all the more critical.
Absolutely. So Anuj, you have been quiet for a while, so let me make you speak. So I think what clearly came out from what Akanksha and Priyanka mentioned, that monitoring those data flows becomes very important. Sorry. Monitoring the data flows within the organizations, and that too in real time, right? So again, technology, I'll be spending a little more time with all of you. But to begin with that, so how does technology come to our aid? Because a lot of solutions, whether it's, of course, solutions which are available at global level, but a lot of innovative work which is happening within the country as well, when it comes to privacy-preserving technologies, privacy-enhancing technologies. So your take on technology would be critical.
So, again, I think Priyanka and both of them covered most of the points that we're discussing, that first, as an organization, you got to have that readiness where the data is, right? And for that, there are enough and more solutions available which can scan data across structured, unstructured data and tell you where your PII data is. Again, the context of Indian PII data versus a US PII data or a European is very different, right? How we write addresses here, opposite Kirana store, opposite this, right? Our PIN code, zip codes, everything is very different. So technology which is made in India, or technology which understands that nuances, is extremely important. Otherwise, the whole exercise becomes futile. Then again, like I'll give you our organization example. When we did our first round of data discovery, there was PII data like PAN, Aadhaar, driving license, other PII data lying all over the place. Some in HR, some in marketing, some in somewhere else, which is not required, right? So again, a technology can help you redact that data. So that's another area where technology will play. Post that, masking, anonymization of data. That's another very, very important element in your thing. What data you need to mask, what you need to store, you need to mask. At some places, which is your UAT data, or data which is lying in, test environment, you need to anonymize that data, like Anuj becomes Priyanka, Priyanka becomes Anuj, right? We need to do all that. Again, technology is available in that space. There are a lot of technologies, all of this can be done by one technology. Then of course it comes to consent management, the DSAR, DPAR. Then again, I think a very good point that Priyanka said earlier is, after taking consent, who's checking back, right? Of course, with this, the power comes to me. Actually, this has been there since, I think, Aadhaar Act coming out. I can even today ask Airtel or Vodafone, where is my Aadhaar card, who all are using it? And if they don't answer me right, I can take them to court. We were not even aware of how this law is going to get implemented, or how much power we have. So I think as we move forward, technology is going to play a very, very important role. Again, unfortunately, the whole cyber security space is very fragmented, right? We have point solutions for point problems. Okay, now Palo and all these guys are coming in with a platform layer. I think privacy also has to be looked as a platform, because you can't have point solutions having some points as solution, and then you then look at integrating them, right? It's not that we are representing one, but I'm saying generally if this problem has to be solved, you have to look at a platform play, not a point solution play. And last but not the least, the intent. I think most, like both of you all said, the finance team or the CEO or the CIO is saying, okay, let's wait for the law. The law is not going to change. We all have been calls of MeitY. I think all of us have been on those panels. Last week all of us were called in by MeitY, and they're saying 15th they might release the document out, right? That's now I think 15th we might release it out. So it's right there. It's not that anything's going to change. It's not that on 15th the new law is going to be completely different than what we've been discussing for the last 2 years, right? So I think it's time is now, right? We have to take privacy very, very seriously. Again, jokes, quote unquote, I think this is more powerful than ED, because now the government, anyone doesn't need to go after anyone. One data loss, they can pick you up, one night of jail, 250 crores of fine, out of business. There are so many elements that they can go after, right? So this again becomes a much powerful, potent weapon in the hands of whoever has it. I'm not saying who's going to use it, but whoever has it is a big thing. The third thing in this which is very important, is law enforcement. They can come after you left, right, and center, and organizations can get out of business. We as CEOs or CIOs or DPOs are responsible for it. We are directly responsible for what's happening there. So again, interesting times, we need to act on it. I think both of you all echoed the same feelings that organizations have to act now.
If I may just add something to this, we've seen a lot of laws come in and they've just gone by. Nobody's really enforced anything. We had this experience I think shared before in other forums as well, that I was working in the US for a while doing GDPR implementation at that time, and a lot of disgruntled employees used to come back with requests for data subject rights request or grievance redressal request. Imagine you are a financial services company, you have so many disgruntled people. So you can just imagine the kind of requests that will come in to access their data, to delete the data, and whether you honor them or not, you have to respond. You have to show that in your records that you have taken some action, and because you had an exemption under the law, that is why you did not delete it or whatever. But you have to go through the process, and that will be very difficult. And this is the kind of volume of requests that are going to come to you. So it's not something that we will see and that can be managed eventually. This is going to become open floodgates for everybody in financial services at least.
So Akanksha, what Anuj talked about, he pointed at some of the aspects, in fact all of the aspects where technology can really plug the gap. Right, but if we were to take a life cycle approach, right, so privacy operations throughout the entire life cycle. So what role you see as a DPO where the technology playing, and especially if you can spend a little more on PR, privacy enhancing tech, because a lot of work is going on privacy enhancing tech, whether it's zero knowledge proofs, whether it's differential privacy, and so on and so forth. So, are we able to leverage PETs and PPTs enough, Or do we not understand them enough, or maybe need to enhance that understanding in order to leverage them, for streamlining our privacy operations?
So I do see when we talk about the data lifecycle, I do see that tech is honestly a game changer for me, because that is helping me out throughout the whole life cycle, from data collection to data classification to from the data discovery, even auto detection of my sensitive PI non-PI data. So overall, throughout the life cycle, I do see that definitely tech can be a game changer for us. Reason being, it can help me to minimize the manual task. Secondly, I can have a real-time check on my data security posture. Where do I stand today? And at the same time, we can work upon how do we can enhance our data security posture. Similarly, one more point which I'll add, especially on the benefit of having such solutions which are emerging now, wherein till now I see that privacy was never into the risk registers. Privacy was never a part of CRO's books any point of time. Privacy was never the point wherein it was supposed to be discussed into the boardrooms. But now, post the DPDP and all, we need to highlight that, okay, this is the biggest risk we are carrying right now. So how we can, judge where do we are today as a privacy score for the organization, and how do we improve this score with the help of all these emerging solutions, wherein we can have a real-time monitoring, real-time dashboards. In fact, we can have those real-time posture management, or the privacy scores dashboards to our CXOs, to the boards, so that they can have a look that where do we stand today, and what kind of mitigation we need to plan upon for this.
Right. So I think just an important aspect, which again, more like a follow-up, that communicating to the boards. Often we have been talking, in fact, we as DSA get opportunity to interact with boards of a lot of organizations. Our CEO interacts that, and especially, we are trying to perhaps work with the CISOs as to how security could best be communicated to the boards. But if we were to talk about privacy from that standpoint, so in your opinion, and then I'll go to Priyanka and Anuj as well, what in your mind, to your mind, is the best way of communicating where do we stand vis-a-vis privacy to your board, to your management?
So one thing I would specifically, no disregards to anybody, but what I believe is the board understand only one thing, which is numbers, rather than the context or rather than the lengthy discussion. So only one thing, if we can highlight the risk which we are associating with the loopholes in the privacy, or how we can improve those privacy gestures, the DSPM in the organization, and vis-a-vis what kind of value in terms of either the ROI, either in terms of the cost optimization, or either in terms of the minimizing the risk. If we can portray it in terms of the number, I think we have already won the bet.
Priyanka.
So I think I agree with Akanksha here. When you are talking to your board, you are convincing your senior management or anyone like that, you have to not talk about the cost of compliance, but the cost of non-compliance, which can be quite huge for financial services companies, especially given that they are regulated. So the reason privacy has become a topic of concern for the board today is because it is now regulated. So anything that is regulated, anything that can impact their bottom line, anything that can, has a risk of their license being suspended, their business being impacted, anything like that will be noticed by the board. It is only a question of how we present it to them as being, a cost of doing business, because there are already a lot of things that we are doing because, for example, cybersecurity. Cybersecurity until a few years ago was not a very, hot topic as it is today, because it was just getting started, and a lot of CISOs had to actually convince their boards to invest in cybersecurity, and today they are seeing the returns of it, and those who did not invest at that time also saw the downfalls of it. So it's the same with privacy. I think privacy, this is the time that we need to convince our boards and our senior management that this is the time to invest in privacy, because the moment the law becomes effective, it is going to impact their bottom lines, and not to mention the reputation. Today we live in a world where one tweet can make or break your business. So that is also another case. People are more aware due to social media. You see even the governments get so impacted because of social media presence. So that's the same thing that will happen to companies as well. So along with the bottom line, it is also the customer trust that you gain, the goodwill that you gain in the market.
Anuj, regarding this.
So I can give you two answers. I sit on a lot of boards where I've answered these questions and the other way around. But again, I think rightly highlighted, the only way you can convince a board is not on saying that, this is, you have to do it, but it's about what's the cost, what is the cost of mitigating that risk, and what is the reputation cost. Because today, I think in the social world today, all of us believe that a reputation cost is much higher than anything else. Right? You lose your reputation, you lose business, and you lose business impacts immediately on your financials, immediately on your balance sheet and on your numbers or the stock market. Or like look at examples of US elections, right? Trump won purely on a reputation on social media. So very important to highlight to the board and to always is that what is the reputation cost loss? How can it get you out of business or reduce your business, and what it can impact if you're listed on the market cap, if you're up for acquisition, on your cost of acquisition, on if you're up for raising money, it will really impact your valuation. So it all depends on which quadrant of business you are and how do you really go back and which domain of business. Financial services is highly regulated. There you can't be ignorant. You can't say that, I'm not going to do it because I don't have the money. Right? But not some domains, there's a manufacturing, or you're still in mid stage of your life in your organization, few of you will be working for that. It's still not that important. So you have to then underplay it or place it. Let's do base one, which is data discovery, or do the first level of foundation of privacy, and then we can build from there on.
Right, absolutely. So in fact, yeah.
Abhinav, may I add one
please,
interesting
please.
point
Please,
into
please.
that? Imagine when you go, just saying a food for thought, let's say if you go to a board and you talk about that this privacy can add into your top line. So definitely you grab all that attention from the board to listen upon that. And definitely it can help you out. Say for example, you are 27701 certified. You build the trust, you get that customer trust, and with that you can bring down your cost of acquisition, your CACs are down. So, and you can have more customers. So acquisition cost also coming down. So at the end, it is going to not just help on your bottom line, it is going to help on your top line as well. So it's just about that how we represent our information to the board so that we can have the right decisions from them.
Absolutely. Yes. No, please. I think we are okay if you chip in.
Normally my voice is good, but I hope everybody gives.
You can take this.
Okay, thank you. That's very nice of you. My question to all the panelists actually is this, which is one reason why I'm attending this particular. It's not just an cliche by saying you can't keep doing the same thing but expect different results. That's a cliche.
Yeah.
Financial industry apart, you go to a supermarket, Aditya Birla, you guys are deep into that, one of your businesses. They need your mobile number to initiate the billing process, right? That was fine, sometime back, harvesting numbers, loyalty points, all that. Today with the advent of DPDP Act, what have you, at senior leaders in your various done to change the way we are capturing data? What have you done? Because while we are looking at all the questions, including what Anuj so well said, he is on both sides of the table, right? And you face the same questions you are supposed to be evaluating on, right? So what have you done, or you could, highlight on what you have done, I'm sure you have. What have you done to change the processes in the light of these developments that have happened? So that, because it's now, and you guys are ahead of the curve. So that was my question. We have to change it, what have you done? So basics, like what I said. Do we really need all the data that we are capturing?
Yeah.
That.
Right.
If I may take up, since you also alluded to Aditya Birla Group. So yeah. It's not financial services, but I'll give you an example of what we are doing. So of course we are not there yet, and we are not ahead of the curve by any means, but we have started the process. And what we are doing is, when you look at our point of sales, what was the process earlier is they used to take your number, feed in the number, and say that you will receive your bill via SMS or on WhatsApp. So what we are trying to do is we are trying to take consent at that point of sales through kiosks, through tablets and all that we put in there, and follow that up with a sort of a deemed consent. So there's one active consent and one deemed consent. So you take an active consent on the point of sales, but again there are ways in which people can say, no, I never did it, that sales guy only said yes and did it. So we follow that up with a deemed consent, which is sent via SMS or whatever, WhatsApp, saying if you want to opt out, you can just stop right here. So we are giving the individual the right that they have under the law. So what is the intent of the law? It is not to follow a certain procedure. It is to give the individual right over their own data, right? It is the principle is that organizations should not be using data, randomly and any way that they want. Currently what is happening, everybody is passing data from here to there. You take one, you apply for one loan, you get 10 calls from different people. We are also offering you. Yes, please.
It's like having a radio button that's already populated and then saying you can choose another one if you don't agree.
No, so that's what I'm saying. So we do take consent. So that is what. No, but you didn't hear me. See, you do take consent at point of sales. There is a way to take consent. But having said that, when you give an individual the right to give consent, there is always a legal chance that the person might say, I didn't do it. How do you ensure that they have done it? By either you go into the app, you take their consent in an app, or you give them a opt-out, opt-in mechanism. See, because eventually, you look at any financial services company also, you cannot make marketing stop completely, right? What will happen? It's not like a button that, say 15th of August, all the marketing will stop unless you have consent. Even the law says where you have taken consent, you just send a notice. You don't require an affirmative action for legacy data, right? So that ability the law already gives you. It is a deemed consent in a way, right? Because you have already collected the data, what do you do with that data? You cannot stop using the data. That way all marketing of all companies will stop, right? So we also want the economy to run. So there is a concept of deemed consent already in the law for all legacy data, and that is what we try to extrapolate.
So I would just add one point to this is, are you carrying an Aadhaar or a PAN right now with you? Have you encrypted that? Okay, in the room, let's ask how many have done it. There'll be 2 people or 3 people. Now, why are we going to organizations? What have you done which is available online right now to encrypt? And you are giving your Aadhaar and PAN at hotel, at airlines, at everywhere. Why are we going after organizations? Because all of us have businesses to run. So now I'm talking from an organization point of view. We have 28 group companies in the country. We have a business to run. Privacy cannot stop our business. All I'm saying is that we need to be very well aware of what our rights are, what that right entails, and as organizations we should not misuse or abuse that data. But at the same time, first, as data custodians individually, what are we doing about our data? Your driver would have a PAN card, Aadhaar, someone is going somewhere, we're just misusing our data ourselves. So I think first and foremost, a lot of effort should be spent on individuals to educate that how you need to safeguard your own data. Then organizations, of course, have to do it. There is no, I'm not even denying it. It is a given. We have to do it. We are data custodians as well for millions of users. We have to do it. But it's a two-way process. And what she said, opt-in, opt-out, have you even once read what is written 3 lines on that? You're just saying, okay, yes, come on, let me go. My wife is crying or my daughter wants to get home. Something or the other, right? And then we go back and blame the organization that how can you misuse my data? So it's a very thin line. I think it's a long way to go. As Indians, we really don't care about our data. I think first and foremost, the DPDP Act at least has got all of us on a dining table to talk about what DPDP is. Today, my 13-year-old daughter comes and asks me, Papa, what is data privacy? I love it, because if she's asking me that, I didn't ask my dad at 18 what is data privacy or what is entitled for my data. So it's an interesting time. I think data is the center of India now, because there is, as we go into the AI world and as we progress in the next 3 to 5 years, and we are seeing a lot of abuse of in social media of the data. It's going to be a very interesting time, how individually we accept it and we change, and how organizations change. That would be my parting note.
Just to add a little bit to this, in our discussions with Mighty, they have also indicated that their training and awareness programs that they're going to do is aimed towards the next generation. So this is a law that is going to impact the next generation more than it impacts us, because we will now be starting on a culture of privacy. And just so you know, I'm not a tech person, I am a lawyer by profession. And in my many years of practicing tech law, I have always noticed that the regulators will look at the intent of the law rather than your procedural aspect. You can have all the tick boxes in place, but if your intent in some way is to find loopholes and get the data out, that is not what the law wants. So eventually, if your intent is to give the rights to the individual, there is no regulator that is going to find fault in that if you are giving rights to the individuals.
I'll just add one last point, sorry. As we step out, there will be a scheme, please give your mobile number and collect a gift. All of us will do that. Right? Will anyone ask what privacy, where privacy, and share the OTP also to collect the gift? We'll be the first ones to queue up and do that, right?
Just last point to add, since he touched upon the AI. AI is something I'm always, when it comes to privacy, I'm always worried about, because the way we pass the PI data to all these LLMs and SLMs, how many, I mean, forget the organization, as an employee or as an individual, how many of us use ChatGPT, Perplexity and all? Almost everyone. Can we have some hands? How many of you take care that you are not writing, when you are writing the prompt, you are not mentioning any kind of PI data in that? Just imagine. We have the proof. So, and we should know that there is no way, if the data is gone for the training in the LLM, there is no way that if someday that data principle comes to you and you want to utilize the right to forget, I don't know how you are going to handle it. So with this,
No, absolutely. I'm also cognizant of the timer right in front of me, which says times is up. So just two things. Of course, by no means 45 minutes is enough to discuss this gargantuan topic. So we've just opened up the threads. Feel free to interact with the experts. And a happy coincidence, in one of the rooms as we speak, one of the DPOs of a large public sector bank is talking about how they have structured their privacy operations. So the idea is that if we are able to just maybe take some cues, that's the only thing, right? We can't really in 45 minutes be discussing or doing full justice. So feel free to engage with the experts. Thank you so much.